Ladies and gentlemen, fellow colleagues in the faculty, I also extend my warm greetings to our esteemed guests for the day. My name is Gaopalelwe Mathiba. I am a senior lecturer in the Faculty of Law here at the University of Cape Town, and I'm also attached to the South African Research Chair on Mineral Law in Africa, a research that is chaired by Professor Henry Mostert. This is the South African Research Initiative. It is a center of excellence for the accumulation and dissemination of knowledge and high impact scholarship on mineral law systems across various African countries. The specific focus for today's seminar is the competing rights on land in the mining context. Here we particularly explore the land use contestations and the challenges associated with the persisting conflicts between mining companies and mining communities over the very limited land resource. For this reason, MLiA, with the assistance of Ms. Fezeka Ntsanwisi, who's attached to the Land and Accountability Research Center here at UCT, we have assembled an impressive panel of discussants to provide a balanced conversation on this important topic. In our panel of speakers, we have Mr. Meshack Mbangula, who is the National Coordinator of MACUA. MACUA is the Mine Affected Communities United in Action movement. It is a movement that advocates for the interests and rights of communities that are affected by mining operations across the country. We have Mr. Elton Thobejane, who is the former national chairperson of the MEJCON South Africa. It is the movement that advocates for the same interest of mine-affected communities. Those two, Meshack and Elton, they are both mine-affected community leaders, and they are very much involved and active in advancing the interest of that category of vulnerability of victims. We also have Advocate Rudessa Harris, who is the Director of Legal Services at the DMRE, the Department of Mineral Resources and Energy. We also have Johan Lorenzen, who is the Director and Practicing Attorney at Richard Spoor Incorporated Attorneys.
From my side, also a very, very heartfelt gratitude to all of the speakers for availing yourselves to us. We hope that this is going to be as meaningful to you as it is to us.
My presentation, which is really an overview laying the foundation for the discussion, I have elected to title it Land Use Conflicts Between Owners of Land and Mineral Right Holders in South Africa. That is the tug of war between the mining companies and the mine-affected communities. What we know by now is that rural communities located in mineral resource-rich areas are often affected considerably by the mining development projects that are taking place in or near the traditional lands and territories of those communities. That we know, we have seen it happening so many times in Limpopo, in the Eastern Cape, in some parts of the Northwest, and in the Northern Cape. Now, the impacts of the mining developments in these communities take various forms. They are social, they are economic, and they are cultural in their orientation, among other things. The South African Human Rights Commission has already documented the plight of these communities in a more comprehensive report they published in 2018. Mine-affected communities were consulted, were engaged to share on how their lived experiences of how the mining companies and the mining enterprises are actually affecting their daily lives. The report is available in the SARChI website. We should consider ourselves fortunate, for we have two mine community leaders in this platform who will speak more to this issue, namely the impacts, the daily impacts of mining in these mine-affected communities. The areas that are often targeted by the mining corporations tend to be mostly occupied by traditional communities that are faced with poverty, inequalities, and high rates of unemployment. We have seen, and I've been engaged in research on this topic for a while, and what I have come to observe is that the rights that these communities have in relation to the lands that they occupy are often informal, meaning that they are not recognized by title or any conventional means of proving or showing or establishing ownership. For this reason, we have seen how mining companies, many a times than not, they assume that the communities do not have a say in the land use decision-making processes that affect their customary lands, even though these processes may have or prove to have direct impact on them, far-reaching impacts for that matter. This assumption is problematic, I argue, for so many reasons. It is wrong. For instance, it is remiss of the provisions that are provided in the Interim Protection of Land Rights, Informal Land Rights Act, the IPILRA, Section 2 in particular, that requires that the consent, the permission, if I say, of the mine-affected communities be sought out all the time in all matters that concerns their traditionally occupied lands or their customary lands. This provision is often, in my view, overlooked. It is often subsumed and applied in subjection to the DMRE and the MPRDA regulations. This is what I exactly problematizes, because my view is that IPILRA and MPRDA must find a way of coexisting. However, I do acknowledge also that the coexistence of mining rights and the land rights of the communities, the mine-affected communities, are often hard to coexist in the real world, in practice. But it is for us, the researchers, the legal practitioners, the thinkers, to come about with mechanisms of making this work out in the most smooth and sustainable way possible. While some scholars would argue that mining rights and community land rights should coexist, as I just said, I observe in my recent research that this is not simple as said in reality. There are a lot of challenges and impracticalities around this assumption. Over the past few years, we have seen so many cases involving the land use conflicts between the right of the owner to maintain the surface of the land and that of the holder of the mineral right to extract the minerals underneath. In a majority of these cases, our courts have been consistent in reaffirming the mine community's informal land rights, including in Maledu versus Itirelemba-Katla mineral resources, the Bengwenyama minerals versus Chinora, and of course the most famous Baleni versus Minister of Mineral Resources, the Golobeni matter, as colloquially oftentimes referred to, among other cases. This is but just a few. There are a lot of other unsaid and unrecorded instances where the mining companies continue to subjugate the rights of the mine-affected communities on the basis that they are informal and there is no conventional title to prove those rights. I will not delve much into the nitty-gritty details of these cases, except to mention that in all of them, the three of these cases, two of which were the Constitutional Court judgments, the community land rights were upheld in all of them. And that is a welcome occurrence, I argued in my latest and recent research output. I know that the Minister of the Department of Mineral Resources and Energy have previously indicated the department's intention to appeal some of these cases, especially the matter on Baleni, one of the Thobejane. According to the minister, Section 2 of the IPILRA, which provides for the seeking of consent before informal land rights of communities are deprived. The minister is of the view that such decision of the Constitutional Court is unfair and should not stand, on the basis that it then means for the department that the minister does no longer retain the power to grant the mineral rights or the exploration rights. He is of the view that the Constitutional Court has took away from him such authority and gave it to the communities that must then decide what happens on their land, which company or which mining company or corporation gets the mining right, and all those finer details, preliminary issues that gets to be determined before the mining right or the exploration right can be given. The minister is of the view that that cannot stand, and that decision must, in actual fact, be reversed. Luckily, we have the Director of Legal Resources from the DMRE here, who, like I said earlier, is responsible to advise the minister on the legalities around these issues. And we do hope that, Advocate Rudessa, you will want to share some further insights on this issue, provided, of course, that you are comfortable doing so, because I know you can be limited in what you share here for the very fact that the department is intending to appeal the case. But I will really encourage you to comment briefly on that and share only to the extent you feel comfortable. I think that has laid enough basis for the subsequent discussants to share their respective views and perspectives on this topic. The topic, like I said, remains the conflict that often arises between the mining corporations and the mine-affected communities. To take this discussion further, I will now give the mic to Mr. Elton Thobejane.
Thank you so much, Mr. Mathiba. Greetings to everyone. I would like to thank you for the opportunity for me to share with you the land contestation experiences and viewpoints in mining communities. And I also want to place it in record that the issues that I'm going to make reference to in my speech are not only synonymous to my local struggles, but are more of a broader reflection of what is becoming an operational norm in mining communities countrywide. Therefore, having said that, let me start by giving a bit of a background and context as to what is happening in mining communities. History tells us that traditional leaders were fighting colonialism and dispossession. Ordinary people were at the forefront of these battles. Many died as soldiers and warriors. They knew what they were fighting for. Land was the primary goal link to the mineral resources, which are still at the center of these battles even today. There is no question as to who the land really belongs to. Land has always belonged to the people. The people had more than evidence to prove this. Their lives was more than enough testimony. The grace of our forefathers stand as an undisputed evidence to this. Colonialism and apartheid may have been declared the thing of the past. However, in the advent of democracy, communities in mining towns and villages still live under suppression and oppression of a new kind. Corporations run roughshod over many communities with deliberate disregard of the law under the watch of the authorities. Regulators turn a blind eye to the flagrant violation of the law mining companies. This is because government officials are actively collaborating with multinational companies, traditional leaders who are supposed to be the custodians of the land on behalf of its people for purposes of administrations that deserted their communities in pursuit for wealth and luxury and lavish lifestyle. They fled with dangerous ideas proposed for the benefit of the ruling or political class, in sharp contrast with our customs, which host consultations so dear to decision-making. Some of my fellow panelists in this webinar know about the struggle of people in the early dawn in the Khatlu village in Limpopo, where the commencement of the large-scale mining development is approved without proper public participation. The surface agreements related issues remains unresolved even today. These are some of the misnomers which goes unchallenged and assumes the current standard in the standing procedures. People identify themselves with the land. There is a strong connection between people and their land. Once the land is taken away and destroyed as a result of mining, the people then lose identity. They lose cultural practices, spiritual connection, and wallow in deep identity crisis. The communities need land for cohabitation and self-sustenance. Mining companies do acquire their mining rights through a process, but their rights are conditional and does not supersede the basic community rights to land. The livelihood of these people is an entrenched right, which is difficult to even make a calculation for. It is immeasurable. We have recently witnessed land invasion in one of the biggest chrome mines in the Bushveld complex in Limpopo. We had ups and downs with the company that blast next to the houses and causing enormous damage to the houses to a point whereby the owners of the same houses has to flee for shelter. These challenges give rise to conflicts and fights over land. As a result, people lose their lives, get intimidated, and in some instances, unfairly detained. Mining does not invest to promote livelihood and the protection of indigenous practices, but instead destroys everything to the benefit of just a few. We now know that government is influenced by capital and interest to collect taxes. Nevertheless, the biggest problem with government, in particular, the mining overseers like the DMRE and large-scale investment companies, is that they have no regard for human rights. The system of mining has not reached the point of beneficiation, as you said, Mr. Mathiba, earlier on. Our government is willing to settle for a colonial model of mineral exchange, export raw material to the former colonial economy, and continue to depend on aid and conditional loans. Only if they have the interest of the affected communities at heart, they will deter human rights violations activities that really occur in mining communities. I thank you. That's the end of my presentation.
Thank you so much, Mr. Elton. Next in our program is going to be Mr. Meshack Mbangula, who is the National Coordinator of MACUA. Mr. Mbangula, of course, is going to give us an overview of mine-affected community issues as he experienced them in his respective space. And his title for the talk is The Inequality, Poverty, Pollution, and Disenfranchisement of Mine-Affected Communities.
Thank you. Firstly, MACUA was formed in 2012, and the reason being that communities were very much sidelined in all programs or decisions that were made regarding economic development, mining development, any other decisions in mining areas. Communities were not being involved in that decision making, and all those decisions were impacting them very much negatively. So, and we have WAMUA, which is women living in mining, are seriously affected by this mining because they bear the brunt of all these results of mining without any benefit from the mining. Based on that, a decision was made that we need to come up with an organizational movement that will forcefully try and force the government to engage them so that they can be part of decision making and implementation of those decisions. And based on that, we had a lot of actions that were done, serious strikes that we were taking, disturbing the meetings that we were taking, mining Lekgotla, which was led by Kgalema Motlanthe, and that was labor, business, and government without communities. And we forcefully stopped such meetings by having marches, striking, and all those things to push, and we have a serious 3 days ICC meeting in Sentin, where there was this mining taking place, meetings without communities. And we managed really to have impact for us to get a recognition as mining affected communities. As of a result, mining Lekgotla, we don't see it anymore, which is led by Kgalema Motlanthe because of those actions. But what really happened is we didn't just end up with only those marches striking, but we look at that is communities are very important, that they should be capacitated for them to be able to fight these mines from an informed base. And we really saw that is mining in these areas. We were aware that is hosting communities are not informed about what should be done regarding the NEMA, National Environmental Management Act, regarding some of the consultation laws that should take place. And now they were taking advantage of that, going in there and, robbing them with issues of employment, saying, give you employment, you give us your land and everything. And it's been happening for quite some time. And we did a good study to say, look, how do we really make sure that these communities can be able to stop these injustices, to infringe their rights? Because if you go to any of the places where mining takes place, you smell poverty, inequality, and obviously there's a lot of emissions that are there. Water is contaminated, cracking houses, and all those things happen. But communities didn't have really a way to say, how do we really fight against these injustices against our rights? And even the Section 24 of our Constitution states very well that is people, they want their rights not to be harmed, but those rights were very much infringed. And there was no way to say our communities can fight that. And we said it's very important that we should look at how do we go to the communities, not only to have meetings, but develop information center that they will be able to engage and fight against this. And amongst other things, we did look at the issues of social and labor plans, to say there is that obligation that needs to be looked at for the mine, prerogative for a mine to get its license. They must develop an SLP. But unfortunately, that SLP, communities were not involved in informing the SLP, because the SLP is meant to address the historically disadvantaged people, socially, that is communities and labor. But unfortunately, those developing of the social and labor plans, communities were not part of that. So they were using maybe consultants to say, look, let's develop, and we just put it in a desk. And mostly, unfortunately, the DMRE was the problem, because there was no monitoring of whether the SLP is being implemented, or there was a really engagement with the community to develop an SLP. So we decided that is through social audit, we need to audit this SLP. We need to go to the communities and engage communities. As a social audit, it's a led community project that is led by communities to be able to start auditing this SLP. And definitely we did so in most of the provinces that were affected by mines and towns. And by doing such, communities were able now to hold these mines accountable, and not just on the social aid, but understanding the issues of how the meaningful consultation should be done. And through the SLP, they saw that there's a lot there was non-compliance with the SLP. And now we're starting to deal with the issues of holding these mines accountable and now engaging them from an informed base, because we had a ground to fight them to say, you didn't comply. This was supposed to be done. These are the obligations you said you do, but close to 80% didn't do that. And the last year, we managed to make a report on the social audit, and we called the minerals councils in our meeting to give them that report to say, look at the mines that are registered under you are not complying, and you have to do something around these things. And we called the DMRE, we gave them that report to say, look, what are the mines doing by non-compliance and what is your part in the scheme? DMRE indicated that, look, I don't have a capacity to monitor these things. How can you say you don't have capacity when you easily issue licenses to these mines who don't really even comply with consultation, engagement with the communities, but you easily issue licenses? So that itself was saying there was part of corruption of issuing of licenses, and that and Mineral Council, we challenged him to say, look, if these are your members, then we'll have to make sure they comply in these issues of complying with the SLP, because those are some of the things that they should make sure that it alleviates the life of communities in the mining areas. But little that happens. And we went on to say, to look at the issue of free, prior, informed consent, to say, look, free, prior, informed consent, those principles are very important to make sure that communities are consulted in a meaningful way, and their views are taken into consideration. And we had a lot of marches to the union building, even to Parliament, and gave them, we had 50,000 signatures, and we gave it to the Parliament to say, look, the issues of mining is a serious problem. And look at the communities that is around South Africa have signed to say, look, we need to be consulted. We need to have our concern taken seriously.
In short, what we said is, as MACUA, we had our own People's Mining Charter, because we were looking at the mining charter, which was to be launched to make sure that our issues are covered in that charter so that it can benefit people. But through consultation, we tried and make sure that we give information that is what people want in the charter. But unfortunately, really nothing came up. And we didn't just keep quiet, but it shows that the government really at any stage don't care. The government really don't care about communities where they are looting minerals without benefiting people. And again, we decided to take, because we believe that the formation of the charter was supposed to be, people should be part of that, and to make sure that the most important things that they want are covered. But unfortunately, that didn't happen. And we end up taking the matter to court, February 2019. And we managed to get a good order from the court to say, yes, we have to be part of the information of the charter to make sure that it's our things are there. But it was later on turned against us. But what I'm saying is that from that time, we have started fighting against the capitalist, ruthless mine and government. Little has been recognized by the government, as you indicated very well, that Gwede is still fighting for his right to make sure that his people remain poor, people don't have rights and everything. And we're still fighting against to make sure that MPRDA is scrapped, because it favors the capitalists, favors the mines and the government. You look at Section 54 and Section 55. Obviously, Section 55 supersedes Section 54, where everyone has to engage and come up with a decision. Section 55 gives the minister the right to overrule whatever come up with the issue of Thobejane. So we need to scrap that MPRDA totally and come up with a law that will talk to the issues of people, and issues of people can have the right. The issues of people from Zamazamas, those are the people who will be solving the problem of unemployment in South Africa. Those are the rightful investors in South Africa. But we see that they are interested in people from outside because they're getting kickback from those people. So we as MACUA, we are fighting to make sure that people have the right and got the voice to talk about, and we need to amplify their voice to make sure they're talking from informed basis. Thank you.
Thanks so much, Ramesh. We are faring well now in our program. We have heard furthermore on how the mining operations continue to sideline and impact directly negatively on the mine-affected communities. And it was an interesting sight for me to actually discover and get to realize that the principles such as the free, prior, and informed consent, the FPIC, meaningful engagement, are also finding some practical currency through movements such as MACUA and the Sekhukhune movement led by Elton. It was an interesting sight and point to note there. the focus turns to you, Advocate Harris. You have heard from the mine affected community leaders. Now, take us through the legal and policy prescripts that regulate how mining companies are to relate with mining communities, and what is the role of the DMRE in clear terms in that regard.
Thank you, Mr. Mathiba. And again, thank you for the introduction as well. Coming into this engagement, I did prepare a little bit on the Mbangula judgment, as well as the Thobejane and the McSands judgments. So maybe just for the audience benefit, if I could just take you through those judgments and what exactly the court found. So we have the Mbangula matter, and the Mbangula Minerals Company basically brought an application to the High Court as well as the Supreme Court of Appeal. And they allege that the prospecting rights application, which was granted to another company, has actually contemplated specifically Section 104 of the MPRDA. And they also argued that the community had actually enjoyed preferential status in the consideration of applications in that particular area. The High Court and the Supreme Court of Appeal, they found against Mbangula. They basically dismissed their applications with costs. The matter was then taken to the Constitutional Court. And in the Constitutional Court, the court actually overturned the decisions of the High Court and the Supreme Court of Appeal and set aside the granting of the prospecting rights to the other company. And very importantly, from the judgment, the court, in a nutshell, found that the community had enjoyed preferential status in terms of Section 104 of the MPRDA, and that they have a preferential right to prospect on community land. The court further found that the DMRE was obligated to notify communities and afford them a hearing in the event of another prospecting rights application being brought on their land. So this matter specifically dealt with consultation. And then maybe just to say a little bit on the department's perspective, this judgment brought in consultation, and consultation has nevertheless remain problematic from an administrative point of view. Nevertheless, the burden of consultation rests on the applicant, and specifically when you find in the EA process, the environmental authorization process, the mining companies have to conduct a PPP process, a public participation process, and therein there has to be consultations with the affected communities. But we found that with some applications, this has proven to be quite complex, specifically taking into account relationships and structures within mining communities. So that's the Mbangula case in a nutshell. Moving on now to the Beleni judgment. This was a key judgment on landowner consultation, but importantly also on consent. So consent, we know, is very different to consultation. Consent is sometimes difficult to obtain. And so the Thobejane judgment obviously brought a little bit of a challenge for the department, because in this matter, the High Court found that the MPRDA and what is known as the Interim Protection of Informal Land Rights Act, IPILRA, commonly known as. Those two acts, the MPRDA and IPILRA, they must be read together. And the court also found that the community now has a right to decide what actually happens on their land, and that they cannot be deprived of land without consent. And not consultation, but consent. So there is a difference there. And the court further held that where land is held on a communal basis, the community must be placed in a position to consider the deprivation of land and to be allowed to take a communal decision as a whole in terms of their customs and their communities and on whether they actually consent to dispose of their various rights pertaining to the land. From a department's perspective, what I can say is that this decision, which brought in consent, is seen by the department as introducing a form of landowner consent in the granting of prospecting and mineral rights. So as you have correctly said, Mr. Mathiba, that the department has indeed filed to appeal this particular High Court judgment. That leave to appeal was lodged as far back as December 2018, from what I can recall. Since joining the DMRE, I've been told that there are delays within the State Attorney's Office, and that's why that matter we haven't heard on a particular date for hearing of the matter. But in a nutshell, what I can tell you is that the introduction of landowner consent is seen specifically for the department as a difficult step to achieve in the actual granting of rights. And in a way, it's viewed as the landowners have to provide consent before the DMRE actually regulates the granting of rights. The consent element must therefore be ticked off. So how practical is that for the department is a question that we are considering. And based on that, there has been leave to appeal filed in December 2018. Just to also quickly touch on the Maxans case, the Maxans versus the City of Cape Town matter. It was a matter that was heard all the way to the Constitutional Court. It's also a key judgment and provides clarity on the relationship between the MPRDA and LUPO being the Land Use Planning Ordinance Act. So in a nutshell, the High Court found in favor of City of Cape Town and the MEC for local government affairs. There was an interdict that the High Court had issued against Maxans, saying that Maxans is basically interdicted from continuing with their mining operations until it had obtained the necessary authorizations under LUPO. And this was specifically because the court looked at Section 23, subsection 6 of the MPRDA, which speaks of relevant law, and the court regarded as that LUPO actually falls under this section in the MPRDA, which refers to relevant law. And specifically also because the MPRDA didn't define or does not define relevant law, so therefore it's accorded a wide definition by the court. Maxan was obviously not pleased with the High Court interdict, so they appealed to the Supreme Court of Appeal, but the Supreme Court of Appeal also found that LUPO authorization was a requirement, and Maxans took it further to to go all the way to the Constitutional Court, and the Constitutional Court again confirmed the High Court and Supreme Court of Appeal's decision. That is Maxan in a nutshell. From a departmental perspective, what I can maybe touch on is that we are undergoing a process where we are now looking at amending the MPRDA, and we are in the process of organizing a summit, and in that summit we want to afford the affected mine community leaders the platform to engage with us, specifically on the fact that the mining charter has now been set aside, and there is transformative issues that are linked to the setting aside of Clause 2.2 of the charter. So we want to afford mine community leaders the platform to engage with the DMRE as well as other players in the mining industry, specifically on their concerns and their issues related to the MPRDA, and to see where can we engage and ensure that we hear what the community leaders have to say, and that we take that into account when we are actually amending the MPRDA. We're also looking at relevant law. We're actually looking deeper into that definition, but it's at its very early stages, and I'm not in a position of giving more detail on that. And so we've actually had engagements with the industry specifically on it. That is my presentation. I hope I've provided a little bit of insight into the department's thinking, and I'm open for any questions that you may have at the end. Thank you.
Thank you so much, Advocate Harris. It is always, the good thing to know and balance the views insofar as this conflict. It was interesting to know what the departmental view is now that we know what the mine affected communities' thoughts are about the whole thing. Johan, the focus will now turn to you. The mine affected communities are saying that we are sidelined. Our land is often, deprived without us having given consent. And now the DMRE is coming and say, but there's a whole lot of impracticalities around the consent issue. You have been dealing with cases of this nature, Johan, and you know the nitty-gritty detail that goes into this kind of disputes. Please tell us what you find to be the common sticking points in your practice in this kind of matters.
Thanks, Gaopalelwe. I have a bit of a structure to the presentation, but I want to just start on the issue of the impracticality and to acknowledge that it's not straightforward to get community consent. You need to have specific protocols for engagement that mining companies simply fail to have or refuse to put in place. You need to have a degree of dignity and respect for the people that you're engaging with, the laws that apply to them. And that impracticality of engagement with landowners is something that has defined the relationship between the state, capital, and common law and indigenous owners throughout South Africa's history with mining. And that impracticality was dealt with for white landowners principally by recognizing a right to say no with exceptions that change through time, and that enabled white people who happened to have the luck of being to sit on top of minerals to become wealthy from that impracticality where it came to indigenous communities was dealt with through forced removal. And so there's always been that degree of impracticality. And the question is, how do we approach that in this democracy? I want to start by, first appreciating Advocate Harris's very clear presentation and the difficult role that the state has to play mediating between various stakeholders, and also specifically acknowledge that Advocate Harris has not been with the department through most of the time period that I'll be describing. What has been very troubling for communities that we work with, and for me personally, is that the state has not, in a welcome sense, they no longer expressly sanction or participate in forced removals. But the state, particularly prior to the Maledu judgment, essentially allowed for those forced removals through the back door by granting mining rights over community land without requiring consent, and usually failing to ensure a Mbangula level of consultation. What the state was allowing was really an open license for companies to engage in that type of dispossession. The companies themselves also did not do that formally. They weren't bringing eviction proceedings. What they do is strike deals with local elites, with traditional leaders, and having done that, they will start mining while they offer piecemeal limited compensation to individuals. And so that becomes what we call in law a constructive eviction. So it's not a formal eviction, but it just makes living intolerable. And you need to think of the impact of these indigenous communities who have had a cohesive social framework of solidarity and collective support, not to romanticize it, and then are faced with their plowing fields being placed under rubble, with literally explosions happening in their vicinity repeatedly and often at all hours. And then their neighbors starting to take deals to move because their neighbors deem life intolerable. And as that happens, the social structure breaks down. And you see a drastic increase in crime, in livestock theft, in theft of crops. And so you see people gradually being forced to move. It's important that we recognize the continuities that we still have from colonialism and apartheid, and deal on a frontal basis with the impracticality. Because for communities, it's very impractical to have explosions happening under their feet, and that doesn't seem to be a significant concern or obstacle to the DMRE. And it's ultimately, there's just a distribution of inconvenience and impracticality that needs to be radically restructured. Also picking up on something Elton raised, we certainly believe in our practice, one of the foundational issues with that is the continued, and Gaopalelwe also made this point, one of the issues is that indigenous land rights are treated as informal, often as state-owned or traditional leader-owned, rather than appreciating the constitutional mandate that we have under our democratic constitution to treat indigenous law or customary law, as it's referred to under the constitution, as equal with common law, subject only to Parliament and the constitution. And to appreciate that position means to recognize that land is owned on terms not described with reference to the common law, but on its own terms. Land is owned by households and by communities in what Professor Cousins called a nested system of tenure. And we as this audience of academics, activists, and members of the state, and hopefully some representatives from mining companies, need to seriously engage in fleshing out how does our law engage with indigenous law? What are the provisions, and take seriously the fact that we have hundreds of years of development in the common law to come to what we now see as common law ownership. It's still significantly fluid, and we need that itself is impractical, and we need to apply the same level of respect and patience if it's required to indigenous law. And touching on consent briefly now, and I'll return to it, that is exactly what the Constitution contemplated. Section 25(6) of the Constitution says that people who have insecure land tenure because of our racist history are entitled to tenure security as provided for by Parliament. As Advocate Harris has noted, that act is the Interim Protection of Informal Land Rights Act. So this is constitutionally mandated legislation. And if we look at the challenges, the drastic increases in poverty, access to water, access to food that we see for communities around mining companies, from our view, the department's decision, conscious or unconscious, to ignore those legal protections that are constitutionally mandated and grant mining rights that deprive people of their rights without ensuring consent is the root of that challenge, for the reasons I've spelled out in terms of constructive eviction. And just to then go into the sort of dominoes of impracticalities that are currently being placed on communities. The most significant that we see is compensation. And the MPRDA provides that landowners or lawful occupiers are entitled to compensation for the loss or damage that they suffer to their land arising from mining activities. Up until guidelines issued by the department a couple of years ago, essentially what the department would give advice on is to pay a market-based rate of compensation, which would typically be paid either to the traditional council or to a trust that it controlled, or but not directly to the people who had the land rights themselves, as well as to strike whatever deal you're able to negotiate with communities. And as I said, that is in the context of communities facing constructive evictions and facing down bulldozers and being arrested for trespassing on their own land. That's the context in which they were expected to negotiate. And that approach to compensation is fundamentally flawed. You know, or hopefully we know from the discourse around Section 25 of the Constitution that it absolutely provides for compensation below market rate, where the factors set out in Section 25 provide for it and require it. And of course, this is something you mentioned UCT, this is something I studied originally under Henry. And so but it's important to appreciate that the inverse is also true. There's jurisprudence from the Constitutional Court in the restitution context that provides that where necessary, compensation must be over the market rate, what is just and equitable. And certainly that is the case here. The market value is going to capture the value of what this land is. Firstly, the land that Black people were allowed to live on is precisely the land that was the least valuable in market terms. Secondly, there's what should be obvious on its face, but certainly is confirmed by growing international and comparative jurisprudence and practice from multinational finance groups and others, that the impacts of these activities on indigenous communities go significantly beyond what the impacts are for a conventional private common law owner. And that because of the specificities of indigenous title that include a social element and a collective element that are just as important to people's dignity and to their conception of their own property rights as the land ownership itself, those factors need to be considered, and they just simply aren't. So I wanted to make 2 points. The point I fundamentally wanted to make on compensation is that by doling out mining rights without ensuring consent, what the department creates for these companies is an unquantified liability, because we don't know yet what the standard of compensation will be. And I'm very confident that litigation will hold it to be very substantial and significant. And so these companies' very viability is placed at risk because their compensation is not determined at the outset, and they believe, because the department allows them to believe this, that they can get away with just shifting the costs of mining onto communities rather than internalizing them into their own structures. But that's simply wrong, and we will be doing litigation on this point, and it's going to be a challenge for industry. Specifically on the question, we already see this in the Tendele example, where a coal mine is displacing community members. They were given the right by the DMRE that they then negotiated and weren't able to reach agreement. Expropriation simply was not an option because the right itself was granted unlawfully. And now the company and the DMRE blame community members for causing the mine to close. They are cast as greedy or what have you, but under our common law ownership system, we don't expect landowners to be the party that has to be reasonable and give up their rights, we have mechanisms that allow for the protection of landowners and a balancing of rights. And for some reason, we've not taken the time to do that for Indigenous communities when they need it, are entitled to it more than anyone else. And the second point I just wanted to make is the best way of addressing this massive risk to the entire industry and to the country's economy is by requiring consent. I think consent is required by a simple, plain reading of the text of the statutes. But I also think it's good policy. And it's not only better for communities, it's better for the state and it's better for industry ultimately. Thanks for everyone's patience and sorry for going over time.
Thank you so much, Johan, for such an insightful perspective to this from public interest litigation point of view. I mean, you are raising quite interesting issues and sticking points there. I mean, constructive eviction, you said, is very critical. And also issues of compensation. How do we calculate the just and equitable compensation in this context? Those are very interesting issues that we have, as you correctly said, us as academics, researchers, legal practitioners, community movements have to wrap our minds on it and actually get to devise workable mechanisms on how to facilitate this kind of conflicts.
Thank you to all the speakers. It was so interesting to hear this story emerging. And I'm so deeply struck by the injustice that is happening here around the law not facilitating the kind of engagements we're supposed to be having in this space. When Johan mentioned the way in which the eviction laws, our laws of this country, is stunting the way in which engagement happens in the communities, and then this roundabout way in which communities then do get evicted and the law gets transgressed covertly. And the same thing keeps happening for the mining communities as well. The mining communities are also in a position where they can't assess their risk. So it's actually quite saddening, but very insightful that the parties who are fighting with each other, the communities and the mine communities, are both pulling on the bad end of the rope, as it were. The interesting and ironic bit is that they're fighting on the basis of a law that doesn't serve either of them. That I found a really profound insight, and thank you for the speakers for highlighting this.
A very special thank you to our panelists for today. I think we can all agree that we're sitting in a position of privilege for having gotten such diverse perspectives on an issue that is important to all South Africans. And I particularly say all South Africans because land is a matter that affects everyone in any shape or form, regardless of the rights or titles you have in it. And in light of the presentations that were given, I'd also like to take an opportunity to also bring our attention to what Johan had mentioned, that our constitution has this aspiration towards implementing a project of land reform, which is made up of restitution, redistribution, as well as tenure security, which is really the mother of this consent requirement that was spoken of in this discussion. And in reminding ourselves then that we also should be asking ourselves, how committed are we as all stakeholders, be it the state, be it these communities, and all of us sitting in this room, to this constitutional mandate that has been placed on us? And in doing this, we ought to also ask ourselves, how will we resolve these issues? How do we balance this aspiration of the Constitution to sort of protect rights such as customary land rights that have been affected by racial injustices caused both by colonialism and apartheid, against these practical implementation challenges that the DMR has brought to our attention? Where do our answers lie? Do our answers lie in us simply looking back to our founding document, the Constitution, and following it as it states? Do our answers lie in being reminded of the fact that this very Constitution also says that we exist in a system of legal pluralism and that we ought to be respecting both the common law and customary law? Or is there something else that we need to be looking back to find answers for? the problem that lies in our country. And it's a problem that stems purely from a massive privilege that we have to be endowed with so much mineral resources. And in addressing these issues in the mining context, we're soon to also have to address the very same problems as we transition into the renewable space. So I'll hand over to everyone in the room, and please ask questions and let's address this issue that has been tabled before us today.
Thank you, colleagues, for arranging this wonderful meeting. I'm a practicing advocate with the Johannesburg Bar, and the topic here is an area of my interest, having obtained a master's degree in 2014 in environmental law, focused on the mining rights and the protection of procedural rights of indigenous people when mining takes place in South Africa. Now, coincidentally, this comes at a time when we are busy drafting an urgent application to be heard on the 20th of June at the Mafikeng High Court. We are acting for a tribal community in Rustenburg against a mining company without giving details. Now, what seems to be the pattern and is cropping out in our case now is the divide and rule by mining companies using their resources, be it management or financial, to break through the communities, and then they establish their operations despite various objections that have been raised either to the prospecting right or the mining right. Now, on the face of all these court cases and legislation that is in front of us, is clear what are the rights of the mining company and what are those of the communities. So mine is not per se a question, but a comment that there is this pattern from all cases. Even now, the mine continue using its strength to divide and rule our indigenous people, and they get away with it, and they mine whether we like it or not. So somehow we need beyond legislation or whatever, because it's coming out, people have been killed. In the face of legislation, the mining will get the rights despite all the objections. So something more drastic has to happen. I don't know what that could be, but we have to go beyond legislation and whatever is happening on the ground. Thank you.
Speaking to the point about divide and rule, it's absolutely what we see. And obviously the companies are in the wrong for doing it. But as society, we should plan for the worst out of companies. We shouldn't rely on their good faith. We should rely on what we require of them. And by requiring consent up front, that drastically limits the ability to divide and rule. There aren't explosions going on. There isn't a pot of money coming in that can be used to shift around. And I wish you good luck, Council, in court.
Thank you for the opportunity. My name is Edward Ditshwele. I'm a medical social worker by profession, but also I'm the provincial spokesperson of Young Communist League of South Africa in the Northwest Province. My question is, in a case where an individual is being given a mining right in a particular community, but instead of hiring the locals, it is found out that the said individual has opted to use the Zamazama brigades to operate the mining. My question would be, what legal recourse does the community have, or what action can community take? Thank you.
My name is Kearabetswe Moopelo, and I am here today also representing the Land National Network Engagement Strategy, known as LANNES, and also in my capacity as an anthropologist, cultural practitioner, and a land activist. I want to pose my question to Johan earlier as he was speaking on the matter on compensation when it comes to the mining companies and the communities that are obviously being cheated out of their land, because what amount of money could actually buy land? So I just wanted to know if are these formulas of calculating compensation expanding to include that which is of cultural significance, that which is of heritage significance, and all these other things that we're sort of not including when we're discussing compensation, because often what the mining companies buy from people is their livelihoods and their home and settlement. But what we're also losing in the process is heritage. We are having, I think, historical erasure happening in mass. I will give you an example of a sacred site we were working on with another law firm in Limpopo, in the Rooiberg area, Madimatle site. The cave is known as Madimatle, and it's an actual sacred site, which SARA had failed to also protect, because we are, I think, currently still as a country struggling with contesting the policies around heritage, which really borrow from the global and the international, and are actually not considerate of the particularly local. And so I wanted to just even ask just on that, because this is a sacred site that is not being protected by SARA, that is not, being considered by the High Court. And what you're having is what was describing earlier as the divide and rule, where mining companies are, basically creating discord, confusion in the community, depriving them of information about what is despondent, and eventually moving in to mine when people are not quite sure what exactly happened there. And then right next to that very same unprotected sacred site, which is under mining threat, is a community known as Rooiberg, which has a squatter camp known as Skirlik, and communities are living there in abject poverty after the promise of development failed completely, as it should. And we have great disastrous ecological disasters there. We have environmental disasters there. People are sick and suffering as a result of the environment they're being forced to live in, and mining companies are not necessarily fixing that issue. And that question, that was going to link to the question I wanted to ask communities that are in these rural and remote spaces into their campaigns for the mining affected communities work that they're doing as an organization. Are they selectively working in the areas where they develop their NGO spaces, or are they also going out to rope out the, that was my question, if I didn't make it too complex.
Touching on Kearabetswe's comment around cultural and heritage harms, looking backwards, we certainly believe that there are very robust and strong claims for, as I said, unquantifiable damages. We will start at a very high level once this comes, and seek very significant damages for that, in addition to the various other heads of damages. And going forward, just to restate the point that these issues are best dealt with through consent. And so communities having the full options presented to them, if they decide they do want to allow a mine to proceed, the best way of addressing culture and heritage is slow and careful engagement. And on that point, again, stress the radical potential. Every single mining right granted under the MPRDA on community land is unlawful because consent was not sought for any of them. Communities in each of those positions have the ability to challenge the fundamental rights granted to these companies. And so I think it's important that communities know that while we fight for legislation that is actually designed to protect them and benefit them, they needn't only put their hopes and efforts into that. They do have robust rights under the MPRDA for compensation and consent.
Well, I welcome the views from Comrade Elton and Comrade Meshack and Comrade Johan. I just want to ask from the comrades who are on the ground, the activists, whether in fact these court victories like your Cholobeni judgment do actually yield into any tangible results on the ground. I'm just interested to know if this really turn into anything meaningful. And I do also wish to just agree with the point being raised, I think also by Johan, that it is practically impossible to really have any meaningful impact in terms of the policies if you do not have the assessment of the viability of the project right from the start, including such things, for instance, as most of these projects are likely to have relocations. That should be something that even with the department assesses, and then if the project does not include practical and just a compensation for those, then the project should be taken as inviable. Thanks.
Thank you, Ncedo, for raising that question. I must first make a point that indeed both Maledu and Baleni judgments are important, and we regard them as a victory for the sector. But as far as its applicability in communities, I'm very much doubtful that they are being applied, because currently we have the Section 54 process within the MPRDA, and the MPRDA often use that Section 54 process, but it is designed to really give mining companies some sort of an edge, to say, we declare a dispute, we declare deadlock. Therefore, then the Section 54 provides that in that case, then one can then opt to approach a court of law. Only at the level of litigations is only when then the 203 judgment then becomes important. But at the level of communities, I can assure you that not even many of us know about these judgments and the implications thereof, So yeah, even the laws that they use to formulate social labor plans, just simple things like social labor plans, communities are not even aware of this. The mining staff do not really use or make reference to these existing laws. So at the ground level, to be honest, we don't see anything as far as these laws are concerned.
Thank you, Bra Elton. Your point really does draw attention to the joint effort, both from state, public interest lawyers, and just generally those who are aware of these laws, to have a joint effort to popularize them, to actually bring them to life.
I did want to lightly quibble with something that Bramish said. Let me start with Bramish's comments that the MPRDA favors companies. It seems to have been designed to do so. However, all legislation in South Africa must be interpreted in a constitutional manner where it's possible to do so, and if it's not, is subject to being found unconstitutional. In our view, reading the MPRDA with its transformative objectives, which formed a big part of the Baleni judgment, together with EPILRA, together with the Constitution, the MPRDA certainly could go a long way in terms of specifying more clearly community rights, so they're not subject to this lack of ability to assess risk, as Henry put it. But in our view, the issue is much more on the implementation than on the MPRDA of itself. We think properly interpreted, the MPRDA doesn't require consent itself, but must be read in parallel with the PILRA, which does. Interpreted by the Mbangula judgment, consultation is not a mere box-ticking exercise. It requires engagement with a view to reaching agreement, which is something more substantial. And that's been fleshed out by the second Baleni judgment, which says that you're entitled to access to a mining right, to be consulted.
Good afternoon, everybody. Christopher Rutledge, I'm with the MACUA Wamoa Advice Office. I just want to take issue with Johan's characterization with regards to the MPRDA. I think it's very important that we must not interpret the MPRDA within a very narrow, legalistic, academic way. The fact of the matter is, and here's where I agree with Elton, the fact of the matter is that the MPRDA was drafted within a time frame within which organized labor, organized business, and government basically sat down around a table and said, how do we mine? There was no consideration in the original drafting of the MPRDA of communities, in its structural expression, in its structural manifestation. The fact of the matter is that communities are completely excluded. They have no avenues, available, accessible avenues for redress, for recourse, or for engagement. So they are excluded across the structure of mining, and that is underpinned by the MPRDA. So for Johan to say that the MPRDA is not business friendly is completely out of context. It has no relevance in its practical manifestation, and it's not the experience of communities. So we need to be very clear when we say things like that. That's all I'd like to say. Thank you.
Most of my comments deals with the MPRDA and the future of the MPRDA. Now, there are various issues that will be discussed in the proposed amendments, as mentioned by Advocate Harris, and thank you to all the speakers for their inputs. And as with all of these events, I really learned so much. So basically, what I'll just say is what is important to remember, that the department is a regulator. That means the department is accountable as regards administrative actions, but also the principles of legality. So in my view, eventually it will devolve that the department will have to monitor, oversee, and evaluate the process of consultation, which cannot be moved only to the actual applicant for a license. Then I do trust that the summit will also be open to interested parties, not only its affected communities, mining houses, etc., etc. And I assume that this amendment bill or the new MPRDA will only be finalized in the new administration. And of course, it will have to go to NETLAC first, which includes not only trade unions, but also civil society, because it's in terms of the legal ambit of them. Then secondly, as far as consultation is concerned, I think much can be learned from recent court cases dealing with the issue of consultation of communities relating specifically to traditional communities, the TKLA, which is still in place for 2 years, and previously the TLGFA. Then there are 4 other bills that are of really extreme importance when reframing, so to speak, the MPRDA, with the new RGR bill, which has been sitting within the department concerned from 2012, the communal land bill, the redistribution bill, and the rural development bill, which will all be tabled by the new administration after the elections next year. Then the Khoisan communities are to be recognized very soon, and there's already been a policy decision that the land-related rights of interest will be granted, probably in terms of the Provision of Land and Assistance Act of '93, which will also have to be taken into account by the department. And then finally, major issues are going to come to the fore as regards restitution and redistribution. What about labor tenants? I mean, that's a key issue. Do they have to give consent or don't they have to give consent? Then there are 6685 community restitution claims, which will take 5 years. How does it affect the granting of if there is a claim on land? The redistribution process will be expedited and more land will be transferred also to communities. I may just mention that the Minister in Parliament mentioned that there are, for the so-called open period 2014 to 2016, there are 163,000 claims that will be dealt with after 2023. The majority of them in respect of undeveloped non-urban land. And then there's finally relevant land. I think we also have to take into account the key role of SPLUMA, which is one of the fundamental laws in South Africa, and by implication also the National Spatial Development Framework, as well as the provincial and the municipal space, which will definitely impact on this. So it will be a contested area when the MPRDA is to be amended. Thank you so much.
Thanks to everyone for the questions and comments. Perhaps if I start with just the MPRDA and its general disposition, it certainly, as I said, it certainly was designed to be business friendly. And the DMRE's actions and principally their lack of actions has enhanced that. But I think it's important to note the radical potential that communities have to use it, and not in an academic sense, but a very real sense.
If I can just agree with Prof there that the DMRE's role is not, just to sit back and lay the onus on applicants to do consultations with the affected communities and landowners, but also a part of our role, or our main focus, is regulation, which includes lawful, procedural and fair decisions being taken. And in so doing, we have to analyze, what's put in front of us and actually apply our minds to, how far has consultation gone, and to the point of even engaging with communities. And, if there are obviously a number of objections to a particular project, the DMR has a vital role to play in that regard. Regarding the summit, if I can maybe just quickly touch on that, the summit's main aim is to basically create a multi-stakeholder platform to identify strategies for the future regulatory regime. So the audience that we are targeting is the mining sector, its key role players in the mining sector, mining stakeholders. We also, as I mentioned, community leaders we will be engaging with, policymakers, influencers, various other stakeholder departments. And we're also looking at inviting certain universities as well. So it is quite a big platform that we are trying to put together. And its aim is to address the challenges with the current regulatory regime, and also to solicit lessons learned and initiatives by stakeholders, which inform the review of the MPRDA and the mining charter. So we are in the phase, as I've mentioned, of planning the summit. And in planning the summit, we are in the process of putting together a list of invitees, and we will definitely extend that to the affected community leaders and maybe to the university, even if we can.
Thank you, Rudessa. I think everyone here is looking forward to the summit you've mentioned. Over to you, Professor Mostert, for the concluding remarks for the seminar.
I would like to thank you and Mathiba again for putting together a beautiful seminar, well visited. Thank you to all the speakers. And with that, I am thanking everybody for their participation, for the thought that they've put into this, and well done, everyone. Thank you very much.